It's a slow trickle today. It's the last week of substantive classes, but it's a slow trickle in today. All right, well, let's get started while the slow tricklers trickle into class. So today is the last class of substantive materials for this semester. So after today, there is no new material you have to learn. So this is both hopefully exciting and slightly scary at the same time. Today we are going to do a number of different things. So I'm just going to tell you a little bit about the content of the exam. Next week, I'll tell you a little bit more about the format and what software you'll be using, etc. And then we'll talk about variations through promises to accept less, and we'll look at it, the common law principles, the principles under the MLAA, and the recent challenges to the existing principles. We'll briefly discuss mutual rescission, and then I think we'll have time to do some exercises on variations, which hopefully will sort of allow these concepts to properly latch into your brain. So before then, I think I have everyone who's on call today. So on call today is Angie, who I saw, Sarah, Thurka, Prajna, and Daniel. So I think I saw everybody. Julia?
On the schedule, I was on call today as well.
Oh, okay, cool. I didn't see it, but I'm putting you on anyways.
Okay, I got a little afraid when I saw my name was. I was like, oh no.
You could be on call for sure. Okay, thank you for letting me know. Okay, so to get ourselves started today, I'm just going to tell you a little bit about the content of the exam. I'll have more details next week in terms of kind of format, word length, etc. But I know it helps when studying to have a bit of a sense of what you'll be looking at. So a couple things to note. So just a reminder, this midterm is worth 20% of your final mark, but it's a fail-safe, okay? And I'll explain again what that means in a second. But first, just to say, your midterm is a midterm, right? It's the first time you're going to get any feedback on what you've been learning so far. There's no special reason why you should magically do amazing. I mean, I hope you all do, right? But that's not the point. The point of these exams is to get feedback, is to give yourself a chance to apply things, to see what's working well, what's not working well, and what to adjust, right? And I know it's really scary and everyone's nervous because it's the first time and everything's new and you just kind of don't know what to expect. But again, the truth of the matter is that these aren't worth a lot. And in my class, it's a fail-safe. And what that means is at the end of the year, after the final, I will calculate your grades, including the midterm and the final and participation. And then I'll calculate it with just participation and your final. And whichever grade is higher is the one that will count. So if you do well on your midterm, it can raise your mark, but it can't drop your mark, okay? And the whole point of that, again, is to bring home the idea that this is not the be-all and end-all of your legal careers. It doesn't demonstrate all you'll be able to do in law. Like I've told you guys before, I did not do well in my first year midterms. I got lots of D's, which I obviously had, well, like most of us, not seen before D. It was really upsetting. And I had come from doing a master's. So I was all like, I know things. And then it turned out I didn't know anything, at least about law. And I know I told you guys this story before, but at that time, Osgood would give us these little papers with all of our grades. And so you had to stand in this stupid lineup. And then everybody's scrutinizing each other's face. Like, oh, she did well. Oh, she did badly, and you're trying to hide in a corner from everybody. anyways, I just assumed everybody didn't do well. And I just was like, isn't this so sad? Like, oh, we did so badly and blah, blah, blah. And after about 2 weeks, I realized everybody I knew had done way better than me and they just felt bad and they didn't want to say anything. And I was like, this is embarrassing. And it was fine. Like, yes, I felt like shit. And then I realized that that's fine. I didn't understand the job until that point, and it took writing these exams to understand the job. It's not, I mean, they told us even less than you're told now. Like, I'd never seen a fact pattern. There was no like, how does one make an argument here at all? We just talked about a bunch of cases. But then I was able to kind of go to my profs and be like, well, what did I do wrong? And there was a consistent problem. Like, I just took the facts as a given. Like, my criminal law exam was like, someone stands over someone else with a bloody knife and the person has a cut in their neck. And I was like, well, you did it. The end. And that was wrong. Okay. And I didn't really get that you could interpret facts in different ways. That just hadn't occurred to me. And I was able to then go back and figure out how to do that and work with different people. And I ended up with good grades at the end of first year. And by the way, mine were final grades because they were, we did like, we were semestered. So all of my midterm exams were all 100% finals. Okay, so those D's stuck around. I couldn't even pretend they were there. But I still managed to do okay for myself. I know I've given this pep talk before, but it's really true, right? This is just the first time you're giving it a shot. And that's why in most of your classes, it's not worth that much. So of course you're going to work hard and you're going to try hard and all those things. But at the end of the day, if you don't see the grade that you love on this, we just sit down together and figure out what happened and how we can make it better. Okay. Nicole?
Well, hi, Professor. First of all, thank you for being so honest because this is a nerve-wracking time. But what I wanted to ask is, because we're going to be switching to a different professor next semester, are we still able to speak to you and like reach out to you regarding the exam or any questions that we have about the material this semester?
Yeah, that's a good question. I haven't talked about it with Professor Roca, but yes, I'm sure that will make sense for us to have what I'll likely do. What I usually do is hold office hours. So I will tell you, I'm a slow marker. I think I'll be able to be a little bit faster this semester, but I do tend to provide a lot of comments and I can't stop myself. The hope is that, like having done this, you'll be able to improve your writing and analysis for the final. So I'm assuming that I would be holding office hours with you after these are marked. And so you would just sign up if you wanted further feedback. What also happens is I provide a model answer with the exam. Again, that takes me more time, but it means that you can check against what I did, again, to be like, well, how come I didn't get a mark here, etc. So you'll have a lot of ways to ensure that you are learning from this experience, because that's the whole point of it. So I'm not sure how we'll set it up with Professor Aroka either. I might come in and do a class together and we go over it, or I'll just set up office hours or both. And then there'll be the model answer as well. So you'll be able to see, there'll be like an Excel sheet with like a breakdown of your mark on every question, and then there'll be comments, and then there'll be office hours. So lots of time to be able to get feedback. Okay, so in terms of the content, my midterm this semester is going to be a bit different format. I'm making it easier for you, okay? Just because it makes it easier for me, and because whatever, it's pandemic life, and it's harder to kind of figure out exactly what's going on in this kind of a context. So usually my midterms are 1 or 2 hypos with lots of issues in them. But I think we've had a little bit less of a chance to work through argument development than we might have in the past. So what we're going to do instead is there's going to be different components to the exam. So there'll be one section that are multiple choice questions and short answer questions. None of these questions are memorization questions. I'm not interested in you memorizing answers that doesn't help you understand them or learn them. It's not a regurgitation process, okay? It's not going to be like, what was the rule in X case or things like that. What it'll usually be is a short hypo and a series of questions that flow from it. And some of them will be multiple choice, which of these, which issue arise from this scenario, or, what could this interaction be argued to be, or, could someone make the following argument, yes or no, etc. And then also short answer questions. So those can be things like, please provide me with a synthesis of the legal principles regarding variation of contracts. It could be, what is the rationale for this rule or for its exception? I might ask you to do like I might have a hypo and it has like one issue, and I might say, okay, just a short answer of the arguments for that issue. So it'll be reasoning questions, okay? Because again, I'm not interested in memorization. Angie, 1 second. And then there will be one hypo. It will not have as many issues as in previous midterms. If you go back and look at my previous midterms, there are 1 or 2 fact patterns with lots of different issues. And instead I'm splitting up the way I'm testing you. So there will be, because we have practiced and talked about, mini IRACs and syntheses and applying and all of this, I want you to have practice for it again, so we can build up to a final, which will be more focused on hypos. And then we'll have a series of other types of questions, which tests your understanding of how to apply and how to explain the legal principles. Angie?
Hi, sorry, this might be a silly question, but so on our exam thing, it says the exam's 3 hours. I just wanted to confirm, is that just a placeholder, or is the exam actually 3 hours?
That should be a placeholder because it's 5 hours.
Oh, okay, thank you.
So what I usually do, like I've been giving take-home exams long before the pandemic, and they're typically 5 hours long. And even when they were just hypos, my idea was that they were the regular length of a regular exam, but you would have more time to answer it, so you would do a better job. Now, the consistent feedback that I have received from students is that they're time pressed. Okay, and that actually they're writing the whole 5 hours. As far as I'm concerned, that only happens if you're not fully prepared. Not because you haven't studied hard, but if you haven't studied the right way. If you have to be sitting there in the middle of the exam, trying to figure out what a legal principle is, trying to figure out what kind of facts are relevant to the application of this test, yes, it will take you way longer, right? But if you come in and you've done the synthesis, you've done the integration, you've thought about what these concepts look like on the facts, then it's relatively straightforward to go through. I don't try and trick anyone. There are, though, sometimes situations where there's a fact and it could look like something significant, but it may or may not be. In other words, that helps me test whether you understand on these facts why if this issue is significant or if it isn't. Okay. There'll be nothing on there that you can't reason your way towards. There may be situations that you haven't seen before that aren't identical to what we've learned, but that's the whole point of legal learning, is that you'd be able to take what you know and reason outwards to figure out how to apply it. So I don't think there's going to be anything on there that comes as a big surprise. There are sometimes questions like, which of these is the strongest argument and why, so there is an evaluative portion of it. So that's what the content will look like. I'm trying to figure out still, like, whether it will be all on ExamSoft or part of it will be on Blackboard, so that the multiple choices could be marked automatically, and how we'll figure that out exactly. And so you will be able, as we've discussed, as like a special dispensation, you will be allowed to cut and paste, which means that if you have your syntheses pre-written, then you may be able to copy most of it. You might need to make some adjustments into the exam. If you've already developed arguments of law that could arise, cut and paste it into the exam, etc. And with the hypo, there will be a word count, because otherwise people just like put their whole outlines in there in the case something in there is correct, and then I want to die. So I've had exams that are like 40 pages because they just dump their whole. Don't do that. And so there will be a word count there, and I stop reading at the end of the word count. Okay. Again, it won't be designed to so that you're like, you know, needing to count every word to make sure it's okay, but it does require you to be tighter in your analysis. You're not just like randomly spewing words that I then have to like arrange and see if I can figure out what they mean, right? You're writing in a concise, tight fashion. Okay, any questions about this portion? Okay, the last thing to tell you is that somewhat unexpectedly, a family issue has arisen, which means that I have to fly to Australia in a week and a half. My family's Australian. And so that is going to be a little bit challenging because I leave on Saturday the 4th and I'll be away till like the 23rd. So what I'm trying to figure out will be, you know, holding some office hours while I'm in Australia. That might mean like doing it at like 4 to 9 p.m. because I'll be like 16 hours ahead of time. But I'll do my best for that to happen. We may also use the discussion board where people can post questions anonymously or with your name on it, and then everyone can see the answer and I'll answer them periodically. So I'll let you know about that by the end of this week. I also, I posted last week model answer to, I think I posted a model answer to the Ali and Doreno situation, but I think I called it Adriana because I was tired. But next week in class, we'll work on a hypo and we'll look at, for the Adriana problem, we'll look at 2 different answers, one that's a bit stronger and one that's a bit weaker to try and think through and see what makes a stronger analysis. And I also will post a model answer for the Irma Twig scenario. So if you want to work on that hypo, you'll be able to compare to the model answer. And I said I would do this by the end of last week, but I forgot. So I'll also post some previous exams that you can work on. Again, they won't look exactly the same as our midterm this year, but they give you just a fact patterns to work with. And so assuming that I can manage to get us connected in office hours before the exam, you're welcome to bring, you know, a fact pattern you've worked on to get some feedback. I think it really is really useful. That's when you tend to know like, oh, I don't actually know how to make this argument. And you have to go back to your facts of the case and figure it out. And it's kind of an iterative process. So these are all the ways in which I'm trying to make sure that you guys are as prepared as you can be going into the exam. I think that's all I can think of for right now. The last thing is that, so next class we'll work on those things together, and I will talk a bit more about the exam format, but if you are feeling like it's more useful for you to not come in that class next week and just take that time to study, that's fine. The exam instructions, I will be providing a document before the exam, so you know exactly where everything is and what it is and what it will look like, and then they will be mostly the same as the exam instructions in there, so there shouldn't be any surprises. That's my spiel. Anyone have any questions? Okay, and then Sarah is having office hours, or is having a tutorial this week, which is an open session. Come with your questions, study questions, strategy questions, all of those. And she'll do her best as always to help you figure those things out. Okay, so then let's move into the material for this week. So as always, a brief recap of what we did last class. So for the last 2 classes, we've been talking about contractual variations through promises to pay more. And those are situations in which 2 parties are in an existing contract, and one party promises that they'll pay more than they were obliged to pay under the original terms of the contract. And the question has been, you know, what is needed to render that enforceable? Is fresh consideration needed? We have cases that say yes, we have cases that say no, we have cases that redefine consideration. So We know that the traditional rules from Stoke and Merrick as applied in Ontario in Gilbert Steel is that if somebody makes a promise to pay more, the other party, the promisee, has to provide them with something new, something they weren't obliged to do under the original contract, to provide them with consideration and render the variation enforceable. So both parties need to provide each other with something they weren't obliged to do under the terms of the original contract. We know that that principle was developed from a concern with coercion, that a party could just threaten to breach their contract to force the other one to pay them more. And so in the mid-19th century, the way the English courts dealt with that is to say, you know what, we'll use the principle of consideration and we'll require fresh consideration to both parties to ensure that that can't happen. But we've also seen that it often will make good commercial sense to pay someone more than you initially contract for a variety of reasons. Underlying circumstances have changed. The markets have changed. The initial contract price is simply not enough to allow the person to do what they were supposed to do, like in Roffey Brothers. In the UK, this has been addressed by expanding the concept of consideration. And so in Williams and Roffey Brothers, I think it was a Court of Appeal held that so long as the promisor was receiving a practical benefit, that could constitute fresh consideration. And we saw that a practical benefit arises where the promisor benefits from promising to pay more, but what they get is not anything new than what the promisee was required to do under the original contract. So what they might get is an increased chance of receiving the consideration promised under the original terms of the contract. So an increasing chance that the contract will be performed as it was required to, avoiding the need to sue for breach of contract, to get someone to replace the services, etc. Right? So they can use what they can get is really like a greater chance of just having this contract performed as promised. The other thing is that they may receive some kind of benefit in the world from that original contract terms being properly performed. So we talked about this situation in Powon, where the Lau brothers really wanted to make sure, it's not a variation situation, but if it was, that the sale went through because they'd already publicized the fact that they had acquired Shingon, right? In Roffey Brothers, they obtained the benefit of not breaching their other contract with the housing association. So these are two ways in which a practical benefit can arise. And of course, if you are synthesizing these principles, you need to explain what a practical benefit is. Otherwise, no one who's trying to apply your principles will know what facts to look at to demonstrate the existence of a practical benefit. In Roffey Brothers, the court also said, you know what, in the past, we are concerned for coercion led us to use the doctrine of consideration as a kind of broad brush to protect against that kind of a situation. But since that time, the doctrine of economic duress has developed. And so we should just, as long as there isn't any economic duress, why not enforce a variation so long as the promisor receives a practical benefit? We also saw then that in New Brunswick, the Court of Appeal went even further than Roffey Brothers. And they said, you know, again, like in the past, our concern with coercion led us to use consideration as a way to protect against it. But consideration is a blunt instrument because it would allow promises that were given under coercion, but with, you know, a peppercorn to be enforced, and it wouldn't allow promises to be enforced where there was good commercial sense for making it, and there was no coercion. The promisor voluntarily gave the promise. And what's happened because of this kind of blunt instrument is that the courts have developed all sorts of legal fiction so that they've been able to enforce these kinds of variations where it was fair and made commercial sense to do so. And the court says, well, like, let's stop doing that, right? Let's we'll deal with a rule that doesn't work super well. It's led the courts to make up a whole bunch of stuff to get to fairness. Why don't we just say that a variation through a promise to pay more is enforceable, even if there's no consideration, so long as there's no other doctrine that impedes that. So long as no economic duress is there, why should we care why should we stop this kind of promise from being enforced? So that's where we ended on contractual variations through promises to pay more. We know that there are some traditional principles that continue to bind in Ontario, and we know that there are challenges and cases that have arisen that would allow the promisee or whoever's seeking the variation to argue that the law should change if they don't have any fresh consideration. And at the end of our materials today, we'll talk again about like how one makes an argument that the law should change. Questions on variations through promises to pay more before we go on? Okay. Okay, so this takes us into the second type of variation at issue. And so you'll remember that when we started the question of variations, we discussed the idea that the courts have historically divided up the legal principles between these two situations. So there are overall principles regarding variations. You know, a variation is an attempt to change the terms of a contract that already exists. And all the things that are needed to create a contract are needed to change its terms. So there needs to be offer and acceptance, a definite promise. The promise has to have certain terms. And the question then arises as to when consideration is needed and what consideration looks like in the context of promises to accept less. Again, just as a note, on an exam, you need to be able to identify which type of variation you're dealing with because the legal principles are slightly different. So until you identify what type of variation you're dealing with, you won't know which case law that you're going to need to use. And so how do you do that? You explain, what it is that was required under the terms of the original contract. What is the promise here? And so you can show this is a promise to pay more because this party is promising to provide extra services than what they owed under the original contract, etc. Okay, so the situation of a variation through a promise to accept less is the situation in which a creditor agrees to reduce or extinguish a debt that's owing to them. That debt can be money, it can be goods, it can be services, it can be anything. But it's basically a situation where someone owes you something and you agree that you'll take less or none of it. Okay. So maybe I owe you money and I'm not able to pay all of it, and you agree that you won't enforce the whole original debt. Maybe you say, I'll take half of it. Right? In that situation, you're accepting less and I'm providing less. In the promise to pay more scenario, one party is promising to do pay more and the other one's doing the exact same thing as under the original contract, arguably. In this situation, both parties are doing less. Right? One is accepting less and the other is providing less. Again, the question then is, do you need to provide fresh consideration to render this variation enforceable, and what might that look like? Now, this area of law is very important to everyday life. Most of us exist with a fair amount of debt. Most of our parents deal with debt. Most law students deal with a significant amount of debt. Debt, is one of the main causes of the poverty trap. You're just constantly trying to get out of debt. You can never accumulate. It leaves you treading water all the time. And so the question about, negotiating with people to whom you owe a debt that they might accept less, or they might extend your timeline for repaying, or maybe they won't charge you the full interest, etc. That is massively important to people's lives, right? And the rules that are provided here are, again, a situation where it's not intuitive to someone who has not studied the law what is required to render that kind of a promise enforceable. So there was on the radio a while ago a woman who's like a financial advisor, and someone called in and said they have a massive amount of credit card debt and they just don't know what they're going to do. And she suggested, you might be able to negotiate a repayment plan with the bank. And so this woman, Frances, she had been laid off from her job. So she was having a really hard time meeting her payment obligations. Everything was going onto the credit card. And obviously, as we know, the credit card fees are bananas. And so the woman suggested she negotiate with her bank if she was able to pay some lump sums down in a relatively rapid time frame, and ask the bank to waive the interest fee accumulation. Assume that the bank agrees to that, okay? In that situation, the bank is agreeing to accept less than they're owed, right? They're saying we won't collect on the interest payments you would owe. But the question is, if Frances doesn't provide anything new to the bank, if she just provides the debt repayment, then is that a promise that's enforceable? Can the bank turn around later and sue and demand that she pay the interest? And you can see how much this could affect someone. If you negotiate this kind of a situation, you manage to get out under the trap of this massive debt load, and then you're, focusing your repayment somewhere else, and all of a sudden, the old amount resurfaces. You can really be in a lot of financial trouble. This is the situation that can arise with variations through promises to accept less. So these rules are very actually important to people's lives. The thing to understand, as you may have noticed through these cases, is that a variation through a promise to accept less is also often referred to as accord and satisfaction. It's the same thing, okay, as a variation through a promise to accept less. So with variations through a promise to accept less, we talk about offer and acceptance, certainty of terms, and consideration. With accord and satisfaction, we talk about accord, and the accord is the agreement, the promise. And so in that sense, offer and acceptance, and certainty of terms, right? So it's ensuring that there was a promise made and that it was intended to be binding, okay? What is at issue in these cases is what constitutes satisfaction in different types of situations, because what constitutes satisfaction at common law is different from what constitutes satisfaction under the MLAA or the Judicature Act, and again is different from what is being suggested by Brozas and Toka. Questions so far? Okay. In theory, this kind of sounds like the same issue as with variations through promises to pay more. There's two differences that have arisen. So in the context of promises to pay more, the courts have, for a long time been of the opinion that it can make commercial good sense sometimes, right, to promise to pay more. And they've made up these legal fictions to try and get people there, even if the traditional rule is otherwise kind of harsh. With promises to accept less, the courts have stuck much more rigidly with the traditional common law principles that we'll look at in Folks and Beer. They don't think it makes sense or haven't thought it makes sense to accept less than you're owed. For that simple fact, the court's like, you made a contract and someone owes you something. You're entitled to that thing. Why should you have to give up what you were entitled to? That person got into a contract with you. If they can't pay, that's a them problem. That's not a you problem. right? You're entitled to what you're entitled to, and why should you have to give it up, right? So yeah, you might agree to less, but if you change your mind, you should be able to change your mind because again, you were owed the thing, right? So in the context of these types of variations, the courts have been less willing to sort of try and find an enforceable variation than they have been with promises to pay more. Okay. That is true up until Rosas and Tuca, which we'll see in a few minutes, where kind of out of nowhere, the Court of Appeal was like, no consideration. You're like, okay, we could see it coming over there, but I don't, you kind of came a little bit out of nowhere. Okay, so we'll come back to that in a little bit. So the general rules around the enforceability of a variation through a promise to accept less come to us from a case called Pinnell's case. So here we have, well, actually it's funny, I was reading one of the other textbooks and they were like, the modern rules come from Folks and Beer. And I was like, I don't know if it can be modern if it comes from like 1882. But in the English common law or the Canadian common law, apparently that is. So Pinnell's case, which they refer to a lot in Folks and Beer, set out the original rules on this issue. And so in Pinnell's case, they said for accord and satisfaction, for the reduction or extinguishment of a debt, both parties need to get fresh consideration. So simply providing less than what you owe, that's not good consideration. You have to provide something new to the person accepting less. The issue came up again in Folks and Beer 200 years later. And in that case, it may not be totally obvious, but what Mr. Folks was doing was arguing that actually the law should change so that part performance could constitute satisfaction, that you shouldn't need new fresh consideration, just part performance. That's what he was asking the court to accept, and they refused. Okay. So in Folks and Beer, what happens is that the two had a contract and Mr. Folks breached it and she sued to enforce it, and the court ordered him to repay her 2,000 and a bit pounds. And so that money was owing to her like as soon as the judgment was issued. So he asked her whether she would agree to, instead of one lump sum payment, that he could pay in 2 installments every year until it was paid off. And she agreed, right? And they wrote it out, right? He would pay twice a year until the principal was paid off. And they didn't talk about interest. So Mr. Folks went ahead and paid biannually and paid off the debt. But at that point, Ms. Beer sued to enforce the original obligation so she could get the interest that accrued over that period of time. And so, of course, the question is, was there an enforceable variation through a promise to accept less? So how is this, what are the facts that show that this is a promise, is a variation through a promise to accept less? What are the facts here that allow us to identify that it's that type of variation? Thurka?
Yeah, so the reason why you can identify it as a variation, or what I thought, is because under the original agreement, he was just supposed to pay her 2,090 pounds and 19 shillings. And then the variation of that agreement was that instead he would pay her 500 pounds upfront and then pay her 150 pounds semi-annually, I believe. And then on top of that, Beer also had to agree that she wouldn't bring forth another judgment.
And so why, yes, so why is that a promise to accept less?
Because she's
still gonna get her 2,000 whatever pounds, right?
Right. Because she doesn't have, well, they're arguing that she doesn't have fresh consideration because she wasn't receiving anything from the variations of the contract. So she was making an obligation to allow him to pay it off slower, and she was making an agreement to not to sue him, but she wasn't receiving anything in exchange for that.
Yeah, so the thing that makes it a promise to accept less is that she's getting the repayments more slowly. So instead of having 2,000 whatever pounds in her hand, she's going to get it over a period of time, right? So even if the overall amount of is indifferent, she's accepting less in the sense that she's not getting all her money up front, right? And so you would want to explain that on an exam, right? And be able to say, this is a variation through a promise to pay to accept less because Ms. Beer is agreeing that she will take deferred payment over a longer period of time rather than getting an immediate lump sum. Okay, and so that's less than she was entitled to under the original agreement. Okay, so the first issue, right, or the main issue is, did Ms. Beer receive any consideration for the agreement? And so what does the court say about that? Has she received any fresh consideration? Sarah?
They said that maybe that the $500 upfront payment could have been fresh consideration.
That's what Mr. Folks argues, but what does the court say about that?
I think they say that no, there is no fresh consideration by Mr. Folks.
That's right. So how come that isn't fresh consideration? Daniel?
Hi. I think if I remember correctly, it was because he was already owed, like he already had to pay the $2,000. So just because he was paying $500 now, like the money is still having to be owed to Beer. So it wasn't necessarily fresh consideration.
So he has not done anything different than what he owed under the terms of the original agreement, right? He had to pay, he paid. So what principle do we take from that about what and whether consideration is required to render this type of promise enforceable? Julia?
That payment of a lesser amount is not enough to satisfy a payment for the whole.
Yeah, so just paying less is not good consideration because you're already obliged to do that under the terms of the original contract, right? So the court says, no, we're not changing Pinnell's case, right? Pinnell's case, super old, we love it, we're keeping it. So what they said in Pinnell's case was the payment of a lesser sum on the day it's due in satisfaction of a greater cannot be satisfaction for the whole. So paying less on the day it's due, that in of itself is not good consideration. Why? Because it appears to the judges that by no possibility a lesser sum can be satisfaction to the plaintiff for a greater sum. Doesn't seem to very clearly explain the why here, but what they're saying is like, well, but again, like how can getting less than what you're owed be good? You're owed the more. Why can't you have the more? Right? But they say the gift of a horse, a hawk, or robe in satisfaction is good. For it shall be intended that a horse, hawk, or robe might be more beneficial to the plaintiff than the money, in respect of some circumstances, or otherwise the plaintiff would not have accepted it in satisfaction. What does that mean? Angie?
My interpretation was that the money, like being less, is never like, so let me rephrase it. It's like a greater sum can never be satisfied by a lesser sum, but say maybe like a horse or a hawk could be more utility or value because you can't like quantify someone's value in like a physical item or like a pet or something.
We can totally quantify that value, but yes. So like all these things are expensive, right? Well, I don't know what a hawk costs, but I know that lawyer robes are very expensive and so are horses. So, but in any case, so if a horse, a hawk, or a robe can be good satisfaction, why, like, how does that differ from a lesser amount? Julia?
Is it that they're giving something that they weren't originally obligated? So it's like a new form of consideration?
That's right, right? They're saying you can't just give less, but if you give something new, that's cool. I mean, they're trying to imply a peppercorn, even though these things are kind of expensive, right? They're like, if you give me something else in addition to the lesser amount, then we can make that enforceable. But a lesser amount itself is not good consideration. You're already obliged to provide it. And anyways, why shouldn't they get everything they're owed? Okay. So the court here is saying So Mr. Folks is like, I think we should change the law so satisfaction would be provided by part performance, a lesser sum. And the court is like, no, that is not good consideration. You need to provide something different than what you owed. A lesser sum on itself, that doesn't work, right? So we're sticking with Pinnell's case. That's the argument, okay? Now, so the rule from Folks and Beer, right, is simply that simply paying less or providing less than what you were initially contractually obliged to provide is not good consideration. But if you provide as the promisee something that you did not have to provide under the terms of the original contract, then that can be good consideration to render it enforceable. So if you want to render enforceable, if like I owe you $500 and you agree you'll take $100, I'm going to have to give you something else to render that enforceable. And if I don't, then it's not because you haven't received any fresh consideration. Okay. So this rule was criticized, and there was a decision issued just like a couple of years by the same court before Folks and Beer called, or maybe another court called Coldery and Bartram. And in that case, Sir Jessel stated the following: according to the English common law, a creditor might accept anything in satisfaction of his debt except a less amount of money. He might take a horse or a canary or a cute little tomtit here if he chose, and that was a court in satisfaction. But by a most extraordinary particularity of the English common law, he could not take 19 shillings and 6 pence on the pound. That was a nudum pactum. What is the critique that Mr. or Sir, whoever, Lord Jessel is making here? Prashna?
I think he's saying that the most arbitrary things can be given in order to count for good consideration when you want to have a variation, but rather than just like the most basic form of money, which of course will be useful.
Yeah, so he's like, this is dumb. Like, getting less than what I'm owed is better than getting none of what I'm owed, right? So why can I not get that, but you could give me like a peppercorn and that would work, right? And it's like, this doesn't make sense. And I think the argument, the critique that's being put forward is, yeah, it's better to get less than get nothing, right? And this is going to happen all the time because you know what? Sometimes the other person doesn't have the money. You can sue them. It's still not in the bank account. You're not getting your money back, right? So if you can get some of it, this is useful. So why are we ignoring that from some formulaic idea that you're super entitled to all of it? Well, maybe you are, but you're not going to get it. And you can instead get a silly little, I mean, the tomtit's pretty cute. Like, I feel like that's probably always good consideration, but we get the point. Okay. So is there, so we know that in general, Folks and Beer tells us that to render a variation through a promise to accept less, or for there to be an accord and satisfaction at common law, the parties have to agree that the creditor will accept less, and the debtor, the promisee, has to provide something different than just a lesser amount than what they owed. We saw that there are critiques of that decision because sometimes less of what you're owed is better than none of what you're owed. Now, in Folks and Beer, and quoting Pinnell's case, they tell us what's not good consideration. But if we look at this statement above this line, right? So ignore the gift of a horse, a hog, ignore the peppercorn. Is there anything here in this formulation that would infer something that could be good consideration? I know that sounded like, I guess, my mind, but I think you can do it. Thurka?
Yeah, I was fixated a little bit on like the day part. I was thinking like hypothetically, if instead folks came back like before his debt was due and said, I could pay you £1,800 instead earlier than when his debt was owed, then that could be fresh consideration.
That's right. If they say payment of a lesser sum on the day it's due is not good consideration, well, that sort of suggests that payment of a lesser sum on an earlier date could be fresh consideration. Daniel, did you have other ideas?
Yeah, I'm not too sure if this would apply, but I kind of thought about it as like let's say like a contractor could be like working in someone's basement, and then the person wanted to get the contractor to pay less, they can kind of say, oh, I could recommend you to my friends. If like he actually did have friends that did need like a basement renovation, it could actually be considered like practical benefits for the contractor to accept less.
Yeah, that is not even of a practical benefit. That's actually just for good consideration,
Okay.
right? Like, because they can make a material benefit, that's a material benefit to them, right? So that can be, so anything other than what is owed can be good consideration. And the court is indicating to us, it doesn't have to be of the same value as the debt, right? It also is telling us though, if it's saying it's not good consideration if you pay less on the day it's due, if that suggests that paying less on an earlier date could be good consideration, right? It's what we call an inference. We are inferring from we are inferring the opposite of this statement to be true. Okay. Okay. So in the notes for today, I explained that there is a decision called Foote and Rawlings from the Supreme Court that enunciated a series of other little random, makes not that much sense things that could constitute fresh consideration. So we know generally anything new not owed by the promisee under the original terms, that can be good consideration. And then the courts gives us some specifics. So in Foote and Rawlings, they say, if you change the manner in which you pay the debt, so say you were supposed to pay by like direct deposit, and you give a lesser sum that you pay by check, okay? The court says that's fresh consideration. There's literally no justification for that because there is no difference in the value of the money, right? But we're running with it anyways, because this is what we call a legal fiction. So if you change the manner of payment, so if the original contract stipulates a manner of payment, and then you parties agree to a change in that method of payment, then a lesser sum with a changed method of payment, that can be good consideration. Okay, I see. Thurka, do you have a hand up or is that an old hand?
Sorry, that's my old hand.
Okay, so Daniel, you had your hand up.
Yeah, I actually just had a question. I just want to see if this would kind of fit into this situation. Like sometimes I'll go to like a convenience store and there'll be a specific price. Like I'll be thinking it's $4, but then when I get to the cashier, sometimes they'll ask me, are you intending to pay in cash or like card? And depending on my answer, like the price could change because on their end, they have to do like a $1 payment. Could that be sort of like a promise to accept less in some sort?
It's kind of like they're not really, because you're paying more, but they're not accepting less.
Oh, okay.
I
see what you're saying,
yeah, but it is a kind of thing where it's more like, if in the terms of the contract was like, I want like a certified check, which sometimes you still randomly, right? And then you're like, okay, if you pay me less than what I owe, and you drop off just a personal check at my house, and that's before, then that can be good consideration. I mean, okay, once in a while, it might be slightly more convenient to receive one type of method of payment than another, but there's certainly no difference in the value of it. So, okay, we'll just go with that. Of course, it requires that the original contract have specified a method of payment, because if it's silent as to the method of payment, you're not changing any, right? Angie?
I just had a question. So for payment less than the sum, could it include like paying in a different currency? So say like it's like Canadian, but you're like, oh, I'll pay it in American instead. Like would that count as like in the Foote and Rawling like satisfaction?
So it depends a little bit on the facts. So if it's like, I'm going to pay you, so I owe you 200 Canadian dollars and I'm going to pay you 100 American dollars. Well, arguably that's just regular fresh consideration because American dollars are worth more. And so there's an actual increase in value, right? But if it's like, you're going to pay me like in the Canadian amount in US dollars, yeah, it's a change of method of payment. It's just actually probably going to be more annoying for the creditor, because then they have to like go and exchange it. So that could either be, if that changes the value, then that could just be fresh consideration. Otherwise, yes, that could be just a change in method of payment. Again, that would though depend on whether the initial contract specified a currency, because otherwise it's not a change. Does that answer? Okay. Ashna?
Okay, so I have a question about folks versus beer because of what Durga just said. So
Yeah.
if we're paying less before a deadline can be considered like good consideration by a court as indicated, then like shouldn't folks have like won because he paid off the full debt before the interest was.
No, but he would have had to have paid it before the 2,000 was due at all.
Oh, I see. Okay.
So it's if you pay it before the initial amount was due. Because then you can at least be like, well, I mean, I got some stuff earlier than I was intended to. I didn't get all of it, but I got some money early. So okay, maybe that's fresh consideration. The other one they say is, so yes, payment of a lesser sum if paid before the original contract due date. And then the third one they say is if you pay at a different location, if a location was specified in the original contract. Again, okay, maybe sometimes it's easier if you drop it off at my house as opposed to my place of business, but like most of the time, again, that's hard to see as anything but pretextual. Nonetheless, it's there. So if you see a fact pattern in which, the contract specifies the manner of payment, it specifies the location at which it's supposed to be paid or provided, and the promisee provides less at an earlier time, different time, etc., or different location, etc., you can argue you do have good consideration. So Foote and Rawlings is operating within the Folks and Beer framework, right? It's finding things that would constitute fresh consideration within that Folks and Beer framework. Any further questions about this? Okay. The English Court of Appeal explained the doctrine of accord and satisfaction in the following way. So it just sort of re-summarizes. Accord and satisfaction is the purchase of a release from an obligation, whether the obligation arises under tort or contract, we don't care about tort for right now, by means of any valuable consideration, not being the actual performance of the obligation itself. Okay, so give me something different from what you owed. Okay, the accord is the agreement by which the obligation is discharged, and the satisfaction is the consideration which makes the agreement operative. Okay, again, the accord is the offer and acceptance and certainty of terms. We want to know that the other party has clearly accepted less, right? If I'm like, okay, yeah, I don't know, I guess we'll think about whether you can give me less, and you're like, here's $25 on an early day enforceable, and I'm like, whoa, I have not actually agreed to this, right? So we can have an issue about accord, which again is the same kind of issue around offer and acceptance and certainty of terms. And then at common law, the satisfaction is provided by fresh consideration, which is, we know, something different from what is owed under the original contract, plus these innovations from folks from Foote and Rawlings. Okay. A point here about accord. You can have a fact scenario, and I have them in some of my old exams, where there is an offer and acceptance problem in a variation situation. So we could have a situation where one party says, yeah, okay, I'll accept less if you, but I promise I'll accept less. There's some issue of communication of acceptance, and then the promisor tries to revoke it, right? So we could have an offer and acceptance issue there. We could have a certainty issue where what it is that the party promises to accept is unclear, okay? And if you have that on a fact pattern, then you're doing the same analysis as you are as if the contract was first created, okay? Now, if on a fact pattern, this applies to both types of variations, there's a contract, and I don't tell you anything about what happened when that contract is created. I don't tell you about the dialogue. I don't tell you about all the terms. Well, you don't have, there's nothing for you to assess about offer and acceptance of the original contract, right? And you can move just into looking at the variation. Is this making sense to people? Like if I have a scenario like folks and beer, where they really don't tell us anything about the original contract, right? They just say $2,000, right? In that situation, there's nothing for you to assess about whether the original contract was enforceable. The only thing for you to assess is the variation. If it was a fact where I gave you all sorts of stuff about the offer and acceptance of the original contract and some issues about the variation, you need to show both, right? Okay. Questions about that? Okay. Now, I mentioned, yeah, Brittany.
Hi, sorry, I didn't hit my button fast enough. I was just wondering, on an exam, are we using the language accord and satisfaction, or do you want us to use like agreement and fresh consideration? Does it matter?
No, because you just be explaining, right? You're like, what is the accord? The accord is the agreement. And then we determine the agreement by the principles of offer and acceptance and certainty of terms, right? What is the accord? So it doesn't matter.
Okay, thank you.
Okay, so we saw that with variations through promises to accept less, the court accepted or promises to pay more. The court in Rafi Brothers expanded the concept of consideration to include practical benefit, right? Now we could say, okay, well, why can we apply that in the context of variations through promises to accept less? Because that kind of looks a little bit like what they're doing in Foot and Rawlings, right? So that question came up before the English Court of Appeal in a decision called Reselect Move. And in that case, the court held that a practical benefit does not constitute fresh consideration for variations through a promise to accept less. So it's not open to argue, in England anyways, it's not open to argue that we should change the law to allow practical benefits to constitute fresh consideration for accord and satisfaction. Reselect Move, neither Rafi Brothers nor Reselect Move have ever been applied in Canada, although they have been discussed kind of by many cases. Now, the reason in Reselect Move that they refuse to expand consideration to include a practical benefit with accord and satisfaction is they say that was the exact argument that was made in Folks and Beer, and that was rejected in that case. So how is this the same argument? How is it in Folks and Beer? They're saying in Folks and Beer, Mr. Folks argued that a practical benefit should be constitute fresh consideration. The court said no. Where in Folks and Beer did Mr. Folks do that? Is this a clear question? Prashna?
I think I get what you're saying. So folks argue that the fact that he was paying, that he did the initial payment, like he paid it off and the £2,000 was paid off. That is the practical benefit, that he does not need to pay on interest because Beer Albury has the practical benefit of like the initial payment being paid.
Yeah, so when he says, well, payment of a lesser sum is a practical benefit, right? And the other thing the court says is if we accepted a practical benefit as good consideration with these kinds of, with creditor debtor situations, all variations through promises to accept less would be enforceable because it's always a practical benefit to get some of what you're owed more than none, right? So they said in Folks and Beer, the court, Mr. Folks was like, payment of a lesser sum, that is a practical benefit and that should be good consideration. And the court said no. And in Select Move, they say, you know, this argument has already been tried and rejected in Folks and Beer. And moreover, if we permitted it, then there would never need to be, you know, any sort of traditional consideration flowing to the promisor, because the promisor would always be getting a practical benefit by getting some of what they're owed. So in England, at least, it is not open to argue that a practical benefit constitutes fresh consideration for a variation through a promise to accept less. Okay, questions about this? Okay. So where does that leave us? So we know that for a variation through a promise to accept less, there needs to be accord. So there needs to be a firm promise by one party that they'll accept less. We can use the principles of offer and acceptance to figure out whether there was a firm promise and whether those terms are certain. And we know there needs to be fresh consideration to the promisor, and that has to be something different than what they originally were required to perform, other than a simply lesser amount. We know as well that paying the lesser sum before the original debt is due can be good consideration. That comes to us from Folks and Beer. We know paying at a different location and paying by a different method, paying less at a different location or by a different payment method, that can also constitute fresh consideration. And we know that in England, the court has refused to expand the definition of consideration to include a practical benefit. So that first sort of challenge to the sanctity of Folks and Beer was not accepted in the UK. Okay. And the logic is relatively sound, which is why it was a bit surprising when the Court of Appeal in New Brunswick or in British Columbia adopted Rosa Santoka. But before we go there, let's take a minute with statutory accord and satisfaction. Okay. So what we've been looking at so far are the common law principles for when a variation through a promise to accept less is enforceable. Okay, at common law. But since Folks and Beers was decided in the 1930s, most jurisdictions, most provinces in Canada put out a statutory provision. They provided in the casebook the one from Alberta, from the Judicature Act. In Ontario, we have the same provision. It's in what's called the Mercantile Law Amendment Act. Section 16, so the MLAA. So what the MLAA says, part performance of an obligation, either before or after a breach thereof, when expressly accepted by the creditor in satisfaction or rendered in pursuance of an agreement for that purpose, though without any new consideration, shall be held to extinguish the obligation. What does that say? Thurka?
I'm not 100% sure this is correct, but I think it's supposed to be almost like a protection when someone starts to perform the obligation. So like hypothetically, if I entered into agreement with you where you and I agreed that I owe you like $10,000 and I was going to pay you an installment monthly for 6 months, and then 2 months in, you come back and say, you know what, I'm actually going to add interest to those payments. I think it's supposed to be like, this is a protection for me because I've already started to perform what we had already agreed to under the contract.
Yes.
If that makes sense.
Right. Yeah, that's right. Right. So what the court is saying is, if the parties agree to extinguish or reduce an existing obligation, so the parties have to agree, again, offer and acceptance, certainty of terms. And the promisee has started to begun to perform the obligations under the new agreement. That agreement is enforceable despite the fact that there is no fresh consideration from the promisee. Okay. So under the statute, satisfaction arises from part performance. At common law, satisfaction arises from fresh consideration. Okay. So if we were to apply this rule to Folks and Beer, would the case change? Angie?
I think it would change. It would be more in favor of like the repayment being considered like valid, the contract being valid, because they agreed on the performance, and then folks began repaying the money and the obligation. So he kind of meets the criteria under the MLAA.
Yes, so he would have, the parties agreed she would accept less. He began to perform under that agreement. And if that's the case, then we don't need any fresh consideration from him to render the promise enforceable. Satisfaction arises from his part performance. So this provision was designed to overturn Folks and Beer. Okay. Okay, if that's the case, why did I make you read Folks and Beer? Why can't we just go with the MLAA? Is there a situation in which the common law principles would still apply? Is there a situation not caught by the MLAA? Daniel?
Well, I'm just gonna give it a shot. Well, just going off of Thurka's analogy with the 10,000, could it be if you didn't start like the new forms of payment? So like we agreed to everything, but if there wasn't any like first payment, would that be a time where the folks would work instead of the MLAA?
Yes. So if you have not begun part performing, the MLAA does not apply, right? And if the MLAA doesn't apply, we revert to the common law. So if the Folks and Beer had made this agreement, but before the first biannual payment was due, or before he paid the £500, she took it back, it would not be covered by the MLAA because he would not have begun to part perform. In which case we would still need consideration at common law. Which means that when you're looking at a fact pattern, you need to be thinking to yourself, okay, was there fresh consideration? Yes, no. Was there part performance? Yes, no, right? To figure out which one of these you're dealing with, okay? Sorry, Isabella, you had a question, and then Angie, and then we'll take a break.
I just wanted to ask what would happen in Folks and Beer had there been a statutory amendment then, but you answered that right after, so.
Okay, no worries. Angie?
In the exam, would we explain both principles and say which one we we believe applies and why? Or would we just kind of like stick to the one that applies mainly?
Well, you would explain both usually because you might be able to make both arguments, right? And we'll come back to this in a little bit. You might be able to say, well, she paid early and that's part performance, right? And then you'd have two arguments, one an alternative to the other, that are both strong, right? If you had a situation where there was no part performance, you might just simply say there, is a statutory provision that applies in this circumstance, but it's not at issue here. Okay. Does that answer?
It does. Thank you.
Prashna?
Okay, I might be just like overthinking this,
Right.
but wouldn't MLAA not apply to folks because the fact that like Beer sued him inherently means that she did not agree to accept the lesser amount?
It doesn't necessarily mean that. It might mean she changed her mind.
Okay.
Like, again, if you think about Gilbert Steele, he was like, okay, we'll pay you more. And then he was like, no, we won't. Right. And this is what happens in a lot of the cases. They make the promise and then they try and take it back. And again, I remind you, they don't have to make the damn promise, right? They could be like, no, I'm not accepting less. No, I'm not paying you more. In that case, seeing as you had that option, I don't get why you get to make it and take it back. That doesn't seem right to me, right? Because you didn't have to make it. But that is there because there's those two situations. One is people change their mind, and the question is, are they allowed to? And the other is sometimes, like in Gilbert Steele, you think they're being a bit tricksy, like they make the promise, but they know it's not enforceable, and they're going to take it away. Has a bit of a smell factor to it. Okay, let us take our break and come back at 3:03, and then we will look at Rosas and Tuckas. Okay, let's get us started back for the second half of our class today. So the next issue we'll take up is the question of Rosas and Tucca. So as I said earlier, I think most people were not expecting the Court of Appeals decision in Rosas and Tucca because although there had been these kind of innovations and challenges and questions in the context of variations through promises to pay more, there had been less so with creditor and debtor situations. And I also would have said, up until Rosas and Tucca, that if you were trying to make an argument that the law should change with variations through promises to pay more, you'd be better off arguing for Rafi Brothers because it would be, not asking such a large change in the law from the court. But now we have two courts of appeal in Canada that have each addressed whether fresh consideration should be needed with both types of variations. And they've been adopted by a series of other courts and courts of appeal, which kind of opens the question as to, whether Ontario will also go this route and whether we'll just be generally getting rid of the need for fresh consideration to enforce a variation or not. So what happens in Rosas and Tucca, I tried to explain the facts in the reading notes because it's a bit confusing. Okay, so what happens is Mrs. Rosas came to Canada in the 1990s, and 10 years or so later, 17 years later, she won the lottery. And she very kindly lent her friend, Ms. Tucca, $600,000 so that she could buy a house. And the agreement was for 1 year that she would lend Ms. Tucca $600,000 and Tucca would repay her at the end of that year interest-free. But at the end of the year, Tucca wasn't able to repay and asked Rosas for more time. And Rosas accepted this. And then the same thing happened every year. So for 6 years, Tucca would come back and say, I'm still not able to repay you. Harry says, honestly, the gall of Miss Tucca in this case was beyond belief, although I don't know, maybe something else was going on with her, who knows. But yes, on the facts of the case, it didn't seem the greatest. Miss Rosas seems like an exceptionally generous person. In any case, so at the end, in the 7th year, Ms. Tucca didn't, by that point, bother asking for an extension, and Ms. Rosas didn't give her one. And so at that point, she sued to enforce the original debt and be like, can I please have my $600,000 back? The issue was that the statute of limitations had run. Have you guys learned about statutes of limitations at all? I feel like nobody knows. Is this something that you guys have discussed before? Do you want me to explain a little bit? Okay, so the idea of a statute of limitations is that for each type of cause of action, there is a maximum amount of time within which you can bring a claim. And if you don't bring the claim, like file your pleadings, within that period of time, you can't bring a claim about it anymore. So there are some things, there's some crimes where there's no statute of limitations, which not very many, but there are some that you can file no matter how long ago they've happened. But with civil claims, there are almost always, as far as I know, there's always statute of limitations. And the general limitation period for civil claims is 6 years. So basically 6 years after whatever the breach has occurred or whatever the wrong occurred, after 6 years, you can't sue to enforce it anymore, even if the other person is clearly in the wrong. And so in this case, Tucca argued this limitation date had passed, right? The contract had been made 7 years ago. And so if there was a breach, it happened 7 years ago, and the statute of limitations is for 6 years. So she was statute barred. They say limitation date had run and she wasn't able to sue to enforce. And if the court concluded that the limitation date had passed, that's what would happen. Regardless of whether Toka was in the wrong or not, she wouldn't be able to sue. With some types of claims, the limitation date is 2 years. So it becomes important for clients to know, right? Because they don't necessarily realize that they'll lose their claim at some point. So what Ms. Rosas argued was effectively that there was a variation every year of this contract for 6 years. And it was only in the 7th year that no variation occurred, in which case it's in the 7th year that Ms. Toka breaches. And if that's the case, then she's brought her claim, Ms. Rosas, within 1 year of the actual breach. And so there's no limitation date problem. Okay. Any questions about that piece, or is that making sense? Okay. So there is kind of these two questions in the decision, whether or not the main question is, has there been this yearly enforceable variation? Because if so, then the limitation date hasn't passed. And if there has not been an enforceable variation every year, then the limitation date has run. Okay, so whether or not Ms. Rosas can sue, it depends on what the court finds about whether there were these annual enforceable variations. Okay. This is an issue of a variation through a promise to accept less, because in this case, right, Ms. Rosas was agreeing not to get her money back for another year. So she was agreeing to less. And if you saw facts like this on the exam, you can see that there is no details that have been provided about the offer and acceptance of the original contract, about the certainty of terms and essential terms of the original contract. So you wouldn't need to comment on whether the original contract was enforceable or not. You'd only be looking at the variation. Okay. So what the court does here is go through a whole series of case law and academic commentary that have questioned and critiqued the rule from Folks and Beer. So they say, so first of all, does Ms. Toka provide Ms. Rosas any fresh consideration to render this variation enforceable? And does the MLAA apply? Julia?
The fresh consideration that Ms. Rosas is applying is her forbearance from filing a claim, and the MLAA would not apply because, as far as I understood in the case, she hadn't acted on paying the amount owed.
Yeah, so we're no part performance. So the question is not what does Ms. Rosas give, but what does Ms. Toka give? So does Ms. Toka provide any fresh consideration to render Rosas's promise to accept less enforceable? Sarah?
I think the only thing they said was the help that they provided with, like, the driving them around and helping them in their store, in that convenience store that they bought.
So they say, well, she hasn't provided anything other than maybe these additional services. Now, do they discuss that in the context of normal consideration or in the context of a practical benefit? So, like, is there a reason why we would argue that help that they did was not fresh consideration? I hope that was clear. Daniel?
I'm not too sure if I get the question, but I think they saw it as a practical benefit more than consideration, because it was kind of like an implied friendship that they had. And in her kind of forbearing from, I guess, suing them, she could retain that friendship with her friend and get rides and get help.
Yeah, so they discuss this in the context of a practical benefit. Why, if you think back to the case of Mr. Boutillier, why could that not just be fresh consideration? Julia? Oh, we can't hear you. Oh,
Sorry,
okay.
I'm pressing the wrong buttons. It wasn't considered fresh consideration, or because they were already doing it before any agreement was entered into. Like they were already working voluntarily in the store and providing the rides before the whole agreement began in the first place.
And they weren't like, we will give you this break on the payment if you help us in the store, right? So there was nothing that obligated under the terms of this promise to accept less Tucker to do those things, right? And you remember that the two have to purchase each other's promises for them to be an exchange of consideration. So under Folks and Beer, she would have provided no fresh consideration. The MLAA doesn't apply. There was no part performance. And so the only way for this to be an enforceable variation is if the court changes the law so that no consideration is needed here. Okay. And the court says, you know what, this is an instance where we should change the law, right? Hard cases equals hard law. I don't know, they start off with some rhetorical flourish. And they say, you know, we think that this is an appropriate time to change the law. And they talk about Williams and Rafi brothers, and they say, you know, that there's been this challenge to the concept, to the requirement of the need to provide fresh consideration. They go through a series of cases that in Canada discuss both promises to pay more and promises to accept less. They talk about Select Move and Williams and Rafi brothers, and they talk about some cases from New Zealand, which also seems to enforce variations in the absence of fresh consideration. And then they also go through critiques from a variety of different academics. Now you only get with each of this, like it's been edited and a lot has been removed. And so in the academic commentary, they focus on the piece written by Ryder and by John McCamus. And you can see there the argument about over and under inclusivity that was used in NAV. And a general reasons why it makes commercial good sense to enforce these types of promises. They don't include an interesting critique by Mindy Chen Wishart about the concept of a practical benefit and why she thinks it's actually not a great idea. And if that interests you, you can find it in the full decision. It's a useful decision just to think through all the permutations, but it's 58 pages, so you guys got to get the 10-page version. And then they get to NAV, right? And they say, okay, so, you know, there's been some case law developments in Canada. They say we've never applied Williams and Rafi brother Select Move, but it's been considered a bunch of times. Other countries have kind of moved in that direction. We have some academics that think it's a good idea to change the law. We've got some that think the existing principles are right. And they say, this takes us to NAV, where the New Brunswick Court of Appeal made an even more radical decision than in Rafi brothers, because it held that no consideration was needed to render a variation through a promise to pay more enforceable. And so they say, okay, well, how do we make a decision about what we should do here? And they say the question really is what theory should be used to decide what promises should be enforced and which should not. And they say, you know, on the one hand, we know that the courts the common law courts have said, you know, for centuries that consideration is at the core of an exchange, and consideration demonstrates the seriousness of the party's intent and is what makes the contract into a bargain, and that is needed to have a contract. But they say, you know, the thing is, though, that when you're dealing with a variation, the initial contract does have good consideration. So it's not like we're making contracts out of nothing here, right? The parties have given each other something. And the rule from Folks and Beer and the traditional approaches, those don't they don't consider, you know, what the real intentions of the parties are, right? Instead of thinking about, well, did you really intend this promise? they're looking at whether there was consideration or not. And when they do that, they are ignoring the party's legitimate expectations because it allows one party to retract a promise that they otherwise sincerely gave. And so they say what we should really be looking at is what are the intentions of the parties and what are their legitimate expectations. And they say, you know, we have a bunch of other doctrines that apply when there's a problem with the contract. So we have economic duress if there's a coercion problem. We have the doctrine of unconscionability, which applies when there are very, very unfair terms of the contract. We have public policy. We have a whole bunch of doctrines that are not dependent on consideration that can be used if there is some other problem with this variation. But if there's no other problem like economic duress or unconscionability, etc., and it looks like the parties very seriously intended this to be an enforceable promise, then the promisor should be held to it. Okay. What do they say about the Williams and Rafi brother approach? So we discussed the idea that they already said, yes, there could be some practical benefits here. And so do they say we should adopt Rafi brothers? What do they say about Rafi brothers? Are they into it? It was one of the reading questions, so it's not new. I think it was anyways. Angie?
From what I remember, I don't think they expressly advocated for it, but they did mention that there was like a big discussion in Canada, but it hasn't been directly adopted. Or like
yes, they do say that, and then, but then do they comment on whether that's the rule they should adopt here? What do they say? They say, sure, we could find a practical benefit here from Ms. Toka and her husband doing some stuff, but they say, should we really do that? Is it worth this legal fiction? And they say, no, like Nav, let's stop pretending with this stuff and just say, if there's been a promise to vary through a promise to accept less, and it was clear from both parties this was intended to be an enforceable promise, and there's no other problem with this variation, there's no unconscionability, there's no economic duress, whatever, it should be enforceable absent fresh consideration. Okay. Is this the same rule as NAV? Julia?
In a way, yes, because it's saying that there isn't a need for consideration, but it's only if there, I mean, I guess, sorry, subject to like that there is an intent by the two parties to enter into that agreement, and it looks more on the unconscionability and other public policy issues where NAV mainly focused on economic duress, maybe.
So I think that's at a technical level, it's like, well, here they talk about more other doctrines that could apply than the other. That's true. In substance, though, is it really different? In my mind, it's not, right? Because it's not so much in NAV that they're like, this is all about economic duress. And the reason it kind of looks that way, but the thing is, economic duress would apply regardless of whether there's consideration. So it's not NAV that brought economic duress to bear on variations. Any kind of contract, any kind of variation is going to be subject to all these other doctrines that you'll learn about next semester that deal with problems in the creation of a contract, right? So unconscionability, economic duress, undue influence, misrepresentation, there's a whole bunch of them. Those apply regardless, right? The reason they raise economic duress and NAV is they're like, your tool was overbroad, okay? So we got a better tool now. In the same way here, they're saying, look, if there's no other problems with this variation, we should enforce it, even if there's no consideration. In that sense, they're both saying the same thing, okay? Now, in NAV, they don't expressly talk about the intent of the parties, right? Whereas in Rosas, they make that a kind of center point of their reasoning. Again, in practice, I'm not sure it's that different. Because if you had in a situation under the NAV approach where it's not clear that the promise was intended to be binding, well, then you would have had an accord problem. And then it probably wouldn't have been intended, right? It been enforced. So if the court couldn't see under the NAV approach that there was a real intent to make this an enforceable promise, they wouldn't enforce it under that situation either. To my mind, Rosas and Tuka just kind of better explains the reasoning behind the old rule. So to my mind, NAV does a better job at explaining the problems with Stilk. But Rosas does a better job of explaining why we should adopt this new approach. Okay. Now, if you're making an argument, Hannah, one second. If you're okay, I'll ask you a question. Hannah, go ahead.
Hi, sorry. I just is the standard less in NAV then if they say that there just has to not be coercion as opposed to in this one if they talk about intent, or are you saying that they're similar just by omission and NAV not focusing on intent specifically?
Yeah, I think they're the same because under NAV, even though it didn't say there has to be intent, but intent is required by the requirement for accord, right? There has to be an agreement to accept less. So if the court didn't think that the promisor really meant it, there would have been no accord. And under NAV, there still wouldn't have been an enforceable variation. So effectively, the intent question is there in both situations. But in Rosas, they explicitly say it's that piece that is the reason why we should change the law. But it doesn't make the test different. Does that answer?
Yeah, that makes sense. Thank you.
So in NAV, they explain all the problems that Justice Robertson does with Stilk. Are those the same problems as the problems with Folks and Beer? Is Folks and Beer under and over inclusive? What was the under and over inclusivity issue in NAV? Okay.
I think the over and under inclusive rule was that it was justifying promises that like would have been objectionable, and then it would deny enforcement of like fair and agreed upon bargains.
That's right. Why would they have been objectionable?
Like, for example, it would ignore like the practical benefit in terms of consideration.
No, yes, sort of. Okay, let me see if Genevieve can build on what you've got there so far. So Genevieve?
I was going to say that, so it would be over inclusive in that it would, if there was an exchange of consideration, even though someone had been coerced into giving consideration to create the contract, it would allow that. Whereas it's under inclusive in the sense where there could be no consideration, but also no duress, and parties have made agreements to vary the contract, but they just don't have consideration, like in the Williams and Rafi Bros.
That's right, right? So as Thurka says, the issue with over-inclusivity is that there could be an objectionable promise. It would be objectionable because it was wrought under duress or coercion, but nonetheless, there was some consideration and it would be enforced. And then they said it's under-inclusive because there's situations where there's no problem, there's no coercion, it makes commercial sense, but there's no consideration, so it's unenforceable, okay? Does that concern arise with promises to accept less? Is it over-inclusive? Does Folks and Beer enforce promises where there is coercion if there's a little bit of consideration? Is coercion an issue with promises to accept less? What's the power dynamic between parties when one is asking for the other to accept less? Who has the power? Prashna?
So the promisee has a lower state of power compared to the promise, or actually no, the promiser would be the one with the low sense of power, because they could end up not gaining anything and just end up with a costly legal battle if the promisee is required to provide fresh consideration and not just part of the payment.
Yes, but does the promisor have the capacity to sue to enforce that original debt?
Yes, they do.
So then who really has the power?
The promisor.
The promisor has the power. If you go to the bank and you're like, I owe you some money, will you take this? You know, even if it's not the bank, that's some giant institution, even if it's your friend over there who you owe the money, they don't have to take less, right?
Mhm.
It's the party who is asking for debt relief who has less power. In that sense, they don't usually have the power to coerce, right? So it's not like the situation of a promise to pay more. Coercion isn't really at the core of the issue. Okay? I raise this because that suggests that when you're developing an argument about what is the problem with Folks and Beer, it's not exactly the same as the argument about what's the problem with Stilk and Muir. So when you're developing an argument of law in favor of Rosas and Toca, and you're identifying the issues with the existing rule, it's not the same critique, right? So what was the critique that's been offered of Folks and Beer? We looked at it from Coldery and Bartram. Okay, is that a new hand up or it's an old hand up?
Sorry, old hand, I'll put it down.
So, Prashna?
It's better to have part of the payment rather than none of the payment.
Right. So if you want to argue that Rosas and Toca should be applied, and you're saying, you know what, the existing rule doesn't work, what do? Well, they do part of it in the decision here. They say, look, one, it does make logical sense to get some of what you're owed versus nothing of what you're owed. In that sense, the reasoning in Folks and Beer doesn't make a lot of sense. The court, they say that the provinces have expressed their questioning of the Folks and Beer rationale when they enacted things like the Judicature Act and the MLAA, right? And they said, look, in some situations, we don't need fresh consideration. And again, for the same kinds of reasons. And for that reason, we should say that as long as there's nothing untowards about this promise, if it's sincerely held, it matches the legitimate expectations of the parties that it be enforced. And when it's not, it can create an unfairness to the promisee who is adapting its situation, its debt situations in relationship to this promise of debt relief, right? And so in that sense, these are the problems with the Folks rule as it stands. And so if we adopt this change suggested in Rosas and Toca, we get rid of those problems, okay? So the point here is that although there's a lot of similarity between NAV and Rosas, when you're making an argument in favor of its adoption, the critique of the historical rules is slightly different, okay? Does Rosas and Toca purport to only apply to variations through promises to accept less, or does it seem as if it's trying to apply to all types of variations? Angie?
The wording makes it seem like it applies to all variations, at least in BC. Yeah, that's my interpretation.
Yeah, because it doesn't specifically say like this rule is for variations through promises to accept less or accord in satisfactions. It says when there is a variation, it should be enforceable absent fresh consideration when there's no other problems, right? So arguably in British Columbia, they've collapsed the distinction between the two types of promises. It would still stand insofar as their version of the MLAA would also be available. But it seems like regardless of the variation at common law, no fresh consideration is needed, in which case you probably don't need the MLAA, right? Because you don't need to demonstrate that there was an enforceable variation without fresh consideration. Now, of course, it's, lawyers will argue about that in British Columbia. Some will say, look, NAV, or ROSAS applies to both types of variations. They didn't say it was cabined to this particular situation. And then other lawyers will say, yeah, but it was only brought up in the factual context of a promise to accept less. So it only applies to a promise to accept less. And we'll see what a court goes with on that issue. So where does that leave us, right? Okay. On the questions of variations through promises to accept less, the existing law in Ontario is Folks and Beer at common law, with the additions of Foot and Rawlings and the MLAA under statute. In British Columbia, Rosas and Tucca applies. It's also been applied by the federal tax court. Okay, so it's been adopted in federal jurisdiction and in British Columbia. Again, that means that when you're in Ontario, if you're representing a client that can't show part performance and that can't show fresh consideration, they will want to be arguing that the law should change to get rid of the need for consideration based on what's offered by Rosas and Tucca. Okay. So how do we make these arguments? We talked about this a little bit last week. But I made you a little chart-ish thing. If I can find your chart thing. Okay, I made this. I have the kind of form. It's a bit of a template, and then some facts with variations to promise to pay more, but it's the same with promises to accept less. So the first thing you would do if you're representing a client who's trying to enforce a variation is make an argument that you have fresh consideration. So you're making an argument of fact under the existing legal principles. So the existing legal principles say you need fresh consideration. So, or the MLAA. So you would be making an argument on the facts about why the promisee did provide fresh consideration. Why are you doing that first? Because if you don't have to ask the court to change the law and you can get there on the existing law, your client has a much greater chance of success. If you aren't able to demonstrate that the variation is enforceable under the existing law because there's fresh consideration or part performance under the MLAA, you will argue that the law should change. Now you are making an argument about law. You're arguing about what the legal principle should be, not about how it applies to the facts yet. If you're doing that because you're asking that NAV be adopted, you explain the problems that Justice Robertson set out with the Stilk rule, and then why the rule that he puts forward better addresses the scenario. If you're arguing for Rosas and Tucca, you're bringing up the critiques of Folks and Beer, and why the Rosas approach better addresses the situation, the realities of the situation. So you start with an argument of fact on the existing law. If that fails, you make an argument of law, and then you make an argument of fact on the new principle. So once you said, this is why you should adopt this new principle, you say, and if the new rule is adopted on the facts, I don't need fresh consideration. So this variation is enforceable. Okay. What is the other party doing? They are also making an argument of fact on existing law, and they are arguing there is no fresh consideration or part performance here. On the existing law, the other party loses, and the variation is not enforceable. Okay. And then they're making an argument of law. You should preserve the existing legal principles. They are very, very old. We are a system based on precedent. It's not an incremental change. It gets rid of the need for consideration. Consideration is at the core of the common law of contracts, blah, 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 right? And then you'd say, if you adopt this new principle, nonetheless, this variation can't be enforced. In these contexts, that would mean there would be economic duress, unconscionability, public policy issues. Now, we don't know how to make those arguments, so you would simply be raising them in this context. But the form is make an argument under existing law if you can. If you can't, you make an argument that the law should change, an argument that the law should stay the same, and then make an argument of fact under the existing legal principle. Now, you need to do this if you're the responding party, because if the court changes the law and you haven't made an argument about how you could win under the new legal rule, the adoption of the new legal rule automatically would cancel out your client's position, right? So you have to try and make an argument, say, even on the new legal principle, I can still win. Questions about this? Is this making sense to people? You have to go away and think about it for some time. Okay. I would expect that if either of these issues arise on exam, you are able to do all of this. Okay. This also logically means that it might be a good idea to develop your arguments for and against the adoption of NAV and ROSAS ahead of time. Right. And then you can cut and paste it into the exam. And then you're just making arguments of fact. Okay. Any questions, comments, observations, feelings? Okay. The last piece, the last new legal principle to look at is the concept of mutual rescission. So what we've been looking at for the last few classes is how to change the terms of a contract. If you want to change the terms of a contract, there's two ways you can do it. You can vary the existing terms, which is what we've been talking about, or you can try and unmake the contract altogether and make a new contract on new terms. That second part is called mutual rescission. Typically, if you're just going to be changing, one or two terms, you'd be varying. You're not trying to unmake the whole contract and remake a new one. You're just trying to change these little bits, right? And then we're in a variation situation in all the legal principles we've just discussed. But sometimes you actually are just like, you know what, there's too much to change. Let's just unmake the contract we have and we'll make a new one on new terms. So how do you do that? The parties can just decide, let's just not do that contract anymore. And that's fine. If no one sues to enforce the original contract, then you can just decide, okay? But deciding not to enforce that original contract wouldn't be enforceable in law unless it meets certain characteristics. To mutually rescind an agreement, you have to show facts that demonstrates the parties intended to fully unmake a contract. So the courts will kind of assume a variation unless you can show that, no, they actually meant to take it all down, okay? The other thing is that each party needs to receive fresh consideration for unmaking the contract in the same way as they do to change the terms of the contract. Now, in some situations, mutual rescission can itself provide the fresh consideration, but sometimes it can't. What does that mean? Sometimes what the parties will do is say, I promise that I will forbear from enforcing the obligations that you owe me under the original terms of the contract if you promise me the same. Effectively, each party is promising not to require the other party to do the things that they originally said they were going to do. And in that way, they're each providing each other with fresh consideration because they're both promising to forbear to enforce rights they otherwise hold. Okay. Are we following so far? Question. We are good to this point. Okay. The problem that arises is that if one party has fully performed their obligations, there's nothing for the other party to promise to forbear to enforce because there's nothing to enforce. In that context, mutual rescission doesn't on its own import the required consideration. So say with folks in beer, instead of agreeing to vary the contract, the parties had been like, let's just unmake our contract. and we'll make a new one where you'll repay me, biannually. While Mrs. Beer could promise to not enforce her immediate right to the £2,000, that would be the consideration she's providing him. But she doesn't have any obligations left. So there's nothing that he can say he won't enforce against her. In that sense, there's no consideration he's providing to her because she's fully performed her obligations. If she still had obligations to run, it would work. He would say, okay, you're supposed to be like, I don't know, delivering something to me every 2 weeks. I'm not going to make you do that. And that would be the consideration he provides her. But if she's fully performed, he has to provide something else other than not promising to forbear from enforcing to provide the consideration. So for instance, if we think of Gilbert Steele, right? So the parties could have said, okay, let's unmake our contract and we'll make a contract on the new terms. If, so University Construction had obligations, right, which was to pay the increased price. If University Construction still had things that it was supposed to deliver under the contract, then Gilbert Steele could say, we will not enforce those and you will not enforce ours. And both parties would have fresh consideration. But University Construction had already performed its obligations. In that context, Gilbert Steele has to provide something new. So maybe you would say, I promise not to enforce your obligations under this contract if you promise to enter into a new contract with me, or if you give me something new, right? Mutual rescission on its own can provide the consideration to unmake a contract if both parties still have obligations to perform. If one party has already performed all their obligations, then that party will have to, the other party will have to provide something additional to render the promise not to enforce enforceable. Questions? Okay, well, you can think that through further. Let's do some arguments. Let's do some exercises. So Nathan asked, could the party that already performed the obligations offer peppercorn as fresh consideration? Yes. The thing is, it's so just to be clear though, the party that's already performed their obligations, they're not the one that isn't providing fresh consideration. It's the other guy. So the party that's already performed, they are providing consideration by saying they're not going to enforce the other party's obligation. The other party doesn't have anything new to promise because they can't promise to forbear. So that party would need to offer the peppercorn. No, Nathan, that makes sense, but just to clarify. Okay. So we've seen with accord and satisfaction that there's kind of 3 sets of principles we're working with. There's common law consideration, there's the MLAA, and there's making arguments that the law should change. So we want to figure out, like, when are we going to argue which one of those? Okay, so we're going to look at 3 different situations here, factual situations that each have something slightly different. And that then therefore push towards one set of principles and not the others. And we're using that so you can enunciate to yourself what are the questions you need to ask yourself to figure out which of these 3 sets of principles you'll be using. Okay. Okay, scenario 1. Herman Foster borrows $2,000 from his friend DeAndre Smith to be repaid on September 2nd. In mid-August, Herman is laid off from his job and knows he won't be able to repay the $2,000 by September 2nd. So he asks DeAndre if he would accept less than the $2,000. DeAndre says, yes, I will take the $1,000 and I will forget the rest if Herman repays it by September 2nd and mows DeAndre's lawn for a month every week for a month after that. September 2nd comes along, Herman pays the $1,000. On September 3rd, before the lawn mowing has begun, DeAndre decides he actually really needs the remaining money and sues to enforce the original agreement. How likely is DeAndre to succeed in this scenario? So what do you have to ask yourself to answer this question? Julia?
Was there fresh consideration and was there a part performance of the obligation?
That's right. So in this case, is there fresh consideration? Yes. What is it?
The offer to mow the lawn.
That's right. So when DeAndre promised he accept less, Herman promised he would mow the lawn for a month. Herman was not obligated to mow the lawn for a month. That's something new he's providing. So he's providing fresh consideration. Okay. In that sense, DeAndre does not have a great likelihood of arguing that the variation is not enforceable. Okay. So if there's fresh consideration, there's good. Okay, this scenario. Syra borrows $2,000 from Ali, again, to be repaid on September 2nd. She's laid off. She asks if he'll take less. He agrees to take $1,000 if Syra pays him $500 by September 2nd and the other $500 by October 2nd. Syra repays the first $500 and Ali thereafter reneges and sues to enforce the original debt. How likely is Ali to be able to be successful, and what arguments can Syra make here to enforce the variation? Has she provided fresh consideration? Angie?
There's no fresh consideration, but then moving on to the next part about whether there was partial performance, she did perform giving the first payment, $500. So I think it would be under the MLAA about how partial performance, and they have the agreement that it would be enforceable.
Yeah, so she hasn't provided any fresh consideration because she's paid less, and she's paid on the day that the whole was due. So she hasn't paid early, she hasn't changed the method of payment, she hasn't given anything new. But she has part performed because under the agreement, he asked her to pay $500 by September 2nd. And so she's done part of what she's supposed to do. So under the MLAA, she would have provided satisfaction, right? No fresh consideration, but yes, part performance. Third situation, Leandro borrows $2,000 from his friend Sarah. He's laid off, he can't pay it. Sarah agrees that she'll take $1,000 if he pays her $500 by September 2nd and the remaining by $500 on October 2nd. Prior to Leandro's first payment to Sarah, she changes her mind. And so then she tries to, on September 2nd, before he's paid it, she sues to enforce the whole original debt. Thurka, what's our situation here?
So I'm thinking that because Sarah changed her mind prior to Leandro's first payment, then we could operate under the the folks framework.
And has she provided any fresh consideration?
No, I don't think so.
So she's got no fresh consideration and no part performance. What is it she can do here? What's her only shot here? Or what's Leandro's only shot to render this enforceable? Sierra?
I guess the argument here would be to change the law in order to make it so that you don't need fresh consideration.
That's right. Right? She's got nothing else here, right? So, I mean, this is how you're figuring out where your arguments are. Was there fresh consideration? Was there part performance? If not, law should change. Do you make these as alternatives? Yes, you do. If somebody's got a really strong argument, that there's new consideration, and they've got a really strong argument that there's part performance, maybe you don't need to make the argument the law should change. You would just explain to me, if for any reason the court didn't go with these two, she could make an argument that the law should change, but these are strong arguments. So I haven't elaborated here. If there is like maybe some fresh consideration, but it kind of looks like a practical benefit, not so sure here, then you make your argument for fresh consideration, but it's not the greatest. So you're going to make your argument that the law should change too, or you've got some maybe you've got part performance, but sometimes what people try and argue, and it's like random whether the court accepts this or not, is, well, you asked me not to pay my debt on time, so by doing nothing, I have part performed under this agreement, right? Maybe not, in which case you probably need a second backup argument. Okay. So what you're arguing at any given time depends on your facts and the strength of the available arguments. Your safest bet is to make them all to the extent that you can, one after the other. If you're running out of time, words, and you've got two strong arguments about that there is fresh consideration and that there is part performance, maybe you don't need to develop your whole argument that the law should change, because obviously that takes a little bit more time to do. If you've got like arguments on the other one, then maybe you should be arguing in a backup in the alternative that the law should change. Questions here about all of these pieces? It's making sense to people. I know you guys get to this at time of the class and you're like, no more brain. But it doesn't matter. I require your brain for another 10 minutes. So, Genevieve?
Hi. So this might not be
go for it.
The best question, but so if we were to make an argument that the law should change for Leandro, like what should we, like how extensive should our like why part be? Like, because if we could say like Leandro obviously wants the law to change because that would be best for Leandro in this scenario, but like when we're making like the like why elements, like how far should we go in that explanation?
As far as you need to be able to provide a convincing explanation. There's no formula, right? What's the critique? You make the critique. If you've made the critique well, then that's what you've done. You've explained why it should change. I'm not sure if that answers your question, but it's not, with this one, it's not that extensive an argument, right? It's the idea simply that like, it does make good sense to get part of what you're owed. And it doesn't make sense to say like, oh, I'll just get part of, like, I'll need some kind of peppercorn. Like, no, part of what I'm owed is better than none of what I'm owed, right? To the extent that you develop that, then that's the argument. The argument is a little bit more involved with promises to pay more, but again, it's like verbatim set out by Justice Robertson. You could be like, cut and paste. Here is the problem with the rule from Silk and Mirror, right? I'm not sure if that answers your question.
Yes, thank you so much. That's very helpful.
No problem. Okay, other questions here? You are good on how to figure out which rules should arise, be used, and which ones you're going to argue first, etc., with variations through promises to accept less. Okay. We're going to do this last two exercises. We have two fact scenarios. They're a little bit involved. They're from old exams. And your job is to identify what type of variation we're dealing with. Okay. So in this case, Sally has just opened a new B&B and she's bought a whole bunch of mattresses from SCMS store, so she can have beds, in her rooms in her B&B. So she buys these mattresses on sale and she buys them on a payment plan. So she's supposed to pay a third the price every month and for 7 months. And at that end, it'll be paid off. If she misses a payment date, then a 25% daily interest starts accruing, and the CMS is allowed to ask for the whole remaining. So if she misses her payment on day one, they can start charging her interest, or they can say, actually give me all of the remaining balance. Okay. When she buys this mattress, it is the store says there's no refunds or exchanges, right? So the parties come to an original contract. There's offer and acceptance through the analysis from Boots. You know, if in this case, you don't like, there's not tons of facts about how this happened. So you wouldn't need to analyze the initial contract, but you would need to know what it says. But if one were, you know, offer and acceptance, Sally makes an offer. In this case, the store makes a counter offer that includes their term that it's not refundable or exchangeable. She accepts it, she gives the money, original contract, okay? Within 1 month of buying them, 4 out of the 5 of them break, which makes them really, really bad mattresses, because 4 mattresses breaking in 1 month is a feat, right? So she goes back to the store and they're like, sorry, no refunds or exchanges. And she's like, this is BS. Like, you've sold me these shitty products. And I knew that was the term, but the likelihood, you know, is not great of all of them breaking unless you have terrible quality products. And if you don't give me a refund or exchange, then I'm gonna, you know, put up negative complaints and reviews of you. I'm contacting the newspaper, etc. Right, to let the world know that you are selling shitty products. So on September 30th, which is you know, a day before the first payment on the payment plan is due, the store agrees that to refund her the money. And they say, we'll meet on October 6th and we'll fill out all the paperwork and we will be refunding you your money. And so on the basis of that promise, she does not pay her monthly installment bill on October 1st. On October 4th, the store changes its mind and sends her a letter saying that they would not be returning the mattress. She missed her payment on October 1st, and therefore 25% interest is accruing on the October installment. Okay, what does she want to do here? What would be her goal? Julia?
Since there was, I'm confused on, I'm not sure on like if there was fresh consideration, because I mean, there could be fresh consideration in that she would be promising not to send a negative review, which would benefit the store, and she would be getting her money back. But
sorry, before we get to the consideration problem, she's trying to enforce a variation. That's her goal, right? Yes. What kind of variation is this?
A promise to pay to accept less.
Yes. Why?
Because she had made an agreement to pay the full amount, but she's asking to not pay that. She's asking to not pay anything at the end, I think.
Yeah. So the store would basically be accepting less insofar as they're allowing a return or exchange, which is something they weren't obligated to do, and because they would be giving her her refund, right? So we need to know that so we know which of our rules could possibly apply. So then the next question is, did she provide fresh consideration? So is it fresh consideration when she agrees not to plaster complaints and negative reviews under about the store? What do you think? Daniel?
Similar to Julia, I think that would be because that could be seen as a practical benefit for the company or the mattress store, because she's agreeing not to do what she wants to do in a sense.
Yeah, so she's like, I'm not going to do a bad thing to you. Seems a bit, you know, if she has good grounds for complaints, okay. If she doesn't, that sounds a little bit coercive. Now, is that fresh consideration or is that a practical benefit? Is a practical benefit good consideration for a promise to accept less? Sierra?
No, it's not.
It's not. But is this a practical benefit or is this just fresh consideration?
I would say it's a practical benefit. I think.
Okay. Why isn't it just fresh consideration?
Because I think that either like being a business, it's just kind of incidental if somebody doesn't like your product and goes ahead and makes a negative review anyhow. So it's not necessarily like a commercial benefit because everybody gets negative reviews in the long, like at the end of the day.
Yeah, although on the here they say sort of like they relented. So it seems like they made their promise so that she wouldn't go ahead and do this. Julia?
Could you make the argument that it is a fresh consideration on the basis of Rosas v. Tokas? Because I think they considered her forbearance from filing a claim her form of consideration. So her forbearance here from writing the review is the consideration.
Yeah, it's different because she doesn't have like, there's no like right, that she's forbearing to enforce from the original contract. Like the original contract says nothing about whether she posts negative reviews or not, right? There's no like, if you sign this contract, you can't post negative reviews about us. There are contracts that try and do that, which are a bit BS. And so this is like arguably just good consideration. I'm not going to do something. It's nothing to do with the original contract. And it's something that if you, I'm going to forbear from doing something. And if you think that's of value, then you're going to make me a promise in return, right? Arguably, that's fresh consideration. Is there any part performance? Prashna?
No,
Okay.
because she did not start the monthly installments. She made the new contract for the refund before her monthly installment started.
Yeah, so okay, she hasn't done anything. Now, if the parties agreed that they would refund her the money on October 6th, could you argue that not paying her monthly installment is performance under this new agreement? Maybe.
You can, because her going and changing the contract, that could be considered past performance, or like, because that's the same thing that occurred under, I forgot the name, but like Toka.
So it's not it's the same that happened under the annual variations, right? So you can try and argue that what we agreed to under the variation was me not doing anything. Okay. You can try and make that argument. Again, sometimes the courts go for it, sometimes they don't. They don't have a principle about what they view that argument as. So you can make it. You can probably make it. They might go for it. But it's not like a sure shot by any stretch of the imagination, right? So here you've got like something that's like probably good consideration, but like, and then you've got like maybe part performance, pretty weak, but maybe try it, right? So you're probably also going to want to make an argument the law should change because you've got no surefire shot anywhere else, okay? But we know this is a promise to accept less because here they're giving up a right they had, the right being not to give refunds and exchanges. And like say they had just decided on an exchange rather than a refund, that still would have been a promise to accept less because they are giving up a right they had, which was to not do an exchange. They now have to deal, they lose additional inventory, etc. Okay. Okay. Any questions about this one? Okay. So here we've got, like I just basically steal all my neighbors and like friends' names. So like randomly your name may show up in a fact pattern sometimes. Like trying to come, Mara's my next door neighbor. I don't have a next door neighbor named Igor, but kind of wish I did. So my neighbor Mara got her fence redone recently. So actually it turns out that wood right now is like more expensive than gold. So it's really expensive. So she says to Igor, like professionally is a fence installer. So And she's a bookkeeper. So they agree that Igor will build her a new fence, and he'll do it for half his usual price if she helps him with his bookkeeping for 2 weeks. So the deal is she pays less, and but she provides him with help with his books. So that's well and good. There's your original contract. She pays him the $2,500, and he starts the work. It doesn't say anything in the contract about how long, you know, he has to build this fence. So after 2 weeks, the accounts aren't done. His accounts are a huge mess. And so she's like, you know what, like, I'm just going to keep working on this for you. Okay. And he's really happy because he knows his accounts are a big mess, and he hasn't been able to afford a bookkeeper. He did see that there was a bookkeeper who was giving discount, and he was going to hire that person. But if Mara will keep doing it, that's great. And so he says, okay, great. I'll cook you some dinners while you're doing that work. Well and good, but she does continue working for another 2 weeks, but after that, she's offered a promotion at work, which means she's not going to have as much free time. And so she comes back to Igor and says, I'm sorry, I can't do any further work on your books. And now he's in a bind because the promotion, the discount that he, with the bookkeeper who was giving her a discount, isn't giving it anymore. So he's back to a situation of not being able to afford a bookkeeper to help him. The chances of him suing to enforce this variation are basically slim to none, but we're going to run with it for the purposes of these principles. So what kind of variation are we dealing with here? And what is it? Julia?
The promise to pay more.
Who's making a promise to pay more?
Mara, and offering more services or offering more time to work on his books.
That's right. So she promises him additional work that she wasn't obligated to provide under the terms of the original contract. Does he provide fresh consideration? Thurka.
Yeah, I think he does by like offering to cook her dinners while she works, like the additional time.
So according to Boutillier, is that fresh consideration? Does he make that promise to purchase her promise of extra time? Angie? Sorry.
Did you want me to answer, or was it?
Yes. Sorry, I cut Kirk off mid-thought, but go ahead, Angie.
No, he didn't. Like, 'cause it was a gift after the fact. Like, he agreed, and then he's like, "Oh, I'll cook you dinner too."
Exactly. So he'll try and be like, "Yeah, I gave fresh consideration." She'd be like, "No, you did not make that promise to me to purchase my extra time." If he had come to her and said, "You know what? If you can continue to give me some work, I'll make you dinner." Oh, okay. Maybe the one is for the other. But in this case, she gave this offer, it seems, this promise gratuitously, and he made a second gratuitous promise. Arguably, that's not fresh consideration. And so there's no MLA at issue here. We don't care about part performance. It's a promise to pay more. So the only thing that he can argue is that the law should change, and that it should change either for a Williams and Rothie Brothers approach or for a NAV approach. So does Mara receive a practical benefit for her promise here? Nope, didn't get anything, right? So the only thing he can do is argue that no consideration should be needed to render this promise enforceable. That's his only way he could convince the courts to enforce this promise. Okay. Any questions about any of this so far? Okay, so we will end here for today. And I will be figuring out office hours shortly. As I mentioned, I'm going away like on the 4th, I think, and I'm likely the 2nd and 3rd being just not available. I think you guys have no tutorials next Wednesday after class. So what I'll do next Wednesday is I'll make extended office hours in the morning and after class. I do realize that most of you will not yet be in a position, although you should be, to come and ask me lots of questions, but I really do encourage you, if you are wanting to get feedback on, some piece of writing or synthesis or whatever, next week is our best bet. I am going to try and set up office hours for when I'm in Australia. I just have a slight concern about connection. And so next week is the best, is the safest, but I will make additional time as well. And next class, what we'll be doing is working on some hypos and going through some model answers to see, what's strong about them, etc. And then I'll explain the format of the exam, but I'll also provide that in writing if anyone prefers to take that time to study instead. All good? Yes, Genevieve?
Hi, Professor. I just am a little bit confused about Igor's argument in this. I for some reason, I feel like because Mara didn't mean, I feel like he's saying no consideration is required. However, it's not like Mara wanted to enter into a new contract with him without consideration anyway, as in, do you know what I'm saying?
Try again.
I guess I'm just kind of confused. I'm having trouble articulating myself because of my confusion.
Basically, what Igor would be saying would be, what he would be saying is that this was, this promise was intended to be enforceable, and we should adopt the approach in NAV Canada, in which case he doesn't need to provide any consideration to her to render the promise enforceable, and so she should be obliged to continue to work on his books. She might then argue, however, that there's a certainty problem here, because it doesn't say how long she's supposed to work. Is she supposed to work on these books forever? Or does she actually say no, it does. She says she'll keep working until she's finished cleaning up the job. Okay, so maybe that's sufficiently certain. So what Igor is arguing is that the law should change so that there is no requirement for fresh consideration, in which case, so long as this was a promise intended to bind, it should be enforceable. Does that work, Genevieve?
Yeah, that does. I guess I was confused just because, I was looking at it more from what Mara would argue first, and then she would totally argue probably the opposite, this was just a gift and you can't bind me to a contract based on a naked promise.
And you shouldn't change the law because it's really, really, really old, and consideration is at the core of contract law. Blah, 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 blah. Yeah.
Okay, awesome. Thank you.
Now, Daniel, did you have a question as well? People, you guys can go if you want, or you can stay and hang out and listen to people's questions. Up to you.
I did. I was just when I was reading through it, I was just kind of confused as to how kind of Mara's second offer after the 2 weeks could be kind of only seen as a gift, because I know it's wrong, my thoughts, but I was just, because it says right after the 2 weeks. So from what I felt, she's not doing anything extra, but she was saying that she'll work on it more. And then he agreed and said, I'll make you dinner. So when I first read it, I thought that it could be seen as consideration from both sides, a promise, but then we said it's not. So I was just wondering how
why
instantly that's a gift instead of a.
So the reason is because she makes him a promise, and then he offers to provide her dinners. So for that reason, it doesn't look like she's agreeing to give him more work so she can get the dinners. Oh, and it doesn't look like he's promising to give her the dinners just so he can get the more work. Okay. It looks like she's like, you know what? These are not good books. I'm going to keep working on this, right? And he's like, oh, that's so nice of you. Okay, I'll make you some dinners, right? That's why.
Okay, thank you.
Sierra?
Yeah, so I was just wondering, so when the argument here to change the law, when we're gonna, like, if we were gonna formulate that on an exam, would we have to link like Justice Robertson's reasoning to the specific hypo, like him saying that this is a better way to address the issue of coercion? Do we have to link like that aspect of coercion to the hypo that we're dealing with, kind of thing? Or do we just have to identify that that's what Justice Robertson said? Kind of
So
thing?
there's I think two ways to answer that. So when you're making your general argument about what's wrong with the existing principles from Stilk and Merrick, you're talking about the problem of coercion, because that's around which the rule was designed, right? But when you're trying to say here, like you can say, look, this is a situation. So in your application, like there's two ways you could see, like this is an example of a situation in which the rule is under inclusive, because look, there's no coercion here. She voluntarily rocked up and was like, let me help you with this, right? So why shouldn't we enforce it, right? So you can sort of say, like in this instance is an instance of the unfairness of enforcing the old rule. But the other part of that is that, but you don't have to do that. That's just like one way of developing your argument. What you would be doing is saying, if we apply NAV Canada here, doesn't look like there's any coercion here, but as we know, like if the court found there's economic duress on those principles, it wouldn't be enforceable. But assuming it wasn't, then it should be enforced. So you can use the facts if you want to show an example of the concern with the existing law in your argument about the law. But the bigger thing is that when you are applying your new legal principle to the facts at hand, you're showing that issue doesn't exist here, which is why the new rule should apply. Does that answer, Sierra?
Yes, it does actually. Thank you.
No problem. Prashna?
Okay, so this is about the argument to change the law to Rosa's. How significant is the part where it says that there needs to be, like, both parties need attention and also need like a serious business partnership or a serious business expectation in order to change the law?
So it's not, so that's the theory behind why we should change the law. Are you asking is like how is that applied?
Okay, so like the obiter of this would just be like, you don't need fresh consideration as long as both parties intend to change the contract. So you don't need,
but that's the rule.
okay.
So it's
then
both things, sorry. On the one hand, they say, look, we should be following the legitimate expectations and intentions of the parties. And if we're doing that, the law should change. Okay, because people would generally assume that these things are enforceable if there's no other problem with it, right? So then we say the rule is if the parties intended this to be enforceable and it meets their legitimate expectations that it would be, and there's no other problem, we should enforce. Now, your question may be, how do we determine the legitimate expectations and the intentions of the parties? If that's the question, we do that through the concept of accord and offer and acceptance and certainty of terms. Is this a promise that was intended to be enforced?
okay, yes, thank you.
No problem. Thurka?
Hi, sorry if this is getting repetitive, Professor. So just going back, because, okay, so I understand why there is no consideration for the Igor case now. I need to be thinking back to Boutillier and what's a gift. But so you're saying that the only legitimate argument that Igor would have, because there isn't any proof of consideration or sorry, fresh consideration, would be that like it was just talked about the Toka case. So he would have to say like,
so it wouldn't be Toka here because this is a variation through a promise to pay more. So it would be NAV.
Oh, okay. So through NAV, he would argue about the intention of the parties and like, I intended to enter into this agreement, and like he would have to kind of say like her actions showed like her intention to enter the agreement.
So what you take from NAV, right, there is that there needs to be, like as we know, there needs to be a to vary a contract requires offer and acceptance, certainty of terms, and maybe consideration or maybe no consideration, right? So whether like in Rosas and Tuca, they talk about intent as if it's a separate thing, but it's not. It's already required through offer and acceptance, certainty of terms, or accord. The same through this promises to pay more, right? So the intent of the parties we get to through was there offer and acceptance and certainty of terms? Because if there is, then there was a promise that was intended to be enforced, in which case we don't need any new consideration and under NAV unless there's some other problem like economic duress.
Okay.
Is this making sense?
Yes, I think so. Okay.
Issue is that when in TOCA they talk about intent, they make it seem like that's something different. But the truth is, under a variation, whether we call it accord or whether we call it offer and acceptance and certainty of terms, all the same things are needed as to create a contract. So we need to know that the parties intended that promise to pay more, to accept less, to actually be enforceable. And it wasn't just like, oh, well, maybe, maybe I'll do this. Right? Or if Mara had just said, I'll keep working on the books, well, maybe we would have like a certainty problem, which might undermine the question of intent, because what, is she supposed to work forever? Right?
Mm-hmm.
So it's to say that the intent part, is kind of the rationale, but it's actually already in the rules because we already need there to be offer and acceptance and certainty of terms.
Okay.
Okay.
Okay. I appreciate that. Thank you.
Yeah, no problem. Those are all good questions. Anybody else? Okay, so are there people who would like to meet with me in office hours now? If so, I'm meeting with someone right now, but I can open things up again. If not, for like half an hour or so. If not, we can leave it till next week. Sounds like next week works for people. Okay. Have a good week, my friends. I know it's a stressful time. You can just do what you can do. Your efforts will be good enough, even when they don't come up with the most magical grades ever. It's just a series of skills that we're just practicing, and you will all get to where you need to go. Okay, so just keep going. Get some sleep sometimes. All right, friends. I'll see you soon.